The Severe Accident Punishment Act came into effect yesterday. Why is that a big deal? Well, we've seen these high-profile accidents occur at construction sites, most notably the tragic accident that occurred in Gwangju with the apartment construction there by HDC. Now, this new law seeks to hold people accountable for accidents that occur on work sites and impose more stricter, stringent penalties against them. And the intent of this is to ensure a safer workplace for these people who do often work in very dangerous conditions. So to give us a better understanding of the Severe Accident Punishment Act, we're pleased to be joined by Kim Seung-jin. He's the attorney at DR and Aju LLC, joining us on the line. Hello.
Hello, good morning.
Good morning to you, sir. Thank you so much for joining us. I guess the first question for our audience, could you just briefly tell us what exactly the Severe Accident Punishment Act is all about?
Yes, more than 800 people died of industrial accident last year. That means more than 2 people died of industrial accident every day last year. We've had Occupational Safety and Health Act since early 1980s, but industrial accidents are not decreasing. The Korean Parliament researched why industrial accidents are not decreasing and concluded that it's because under the previous act, not the CEO, but the site manager or the head of a contractor is responsible for the industrial accident. That's why the Korean Parliament enacted the Serious Accident Prevention Act, or briefly SAPA. Compared to the previous act, SAPA contains very powerful measures. First, according to the previous act, only security and health managers were responsible for industrial accidents. Because in most cases, site managers were appointed as security and health managers. Site managers were responsible for industrial accidents. However, according to SAPA, CEOs are responsible for industrial accidents. Secondly, according to the previous act, only employees who have labor relationship with their employees were protected. But under SAPA, every person who works for the employer for its business are protected. That means the person does not have to have a direct labor relationship with the employer. For example, if the employees of subcontractors have industrial accidents, the CEO of the company which originally placed the order is responsible for the industrial accident. Thirdly, according to the previous act, the industrial accidents which occurred in the workplace were protected. However, according to the SAPA, as long as the industrial accident occurred during the course of business which the employer effectively governs, operates, or manages, the accident is protected by SAPA. For example, in the food delivery business, which is booming in Korea, according to the previous act, motorcycle accidents were not protected by the act because the motorcycle was not in the workplace of the employer. However, according to SAPA, the motorcycle accident is protected because the accident occurred during the course of the employer's business. Fourthly, the punishment is strengthened. According to the previous act, in case the accident results in death, 7 or more years of imprisonment or less than 100 million won of fine were imposed. However, according to SAPA, more than 1 year of imprisonment or less than 1 billion won of fine are imposed. In addition, the imprisonment and the monetary penalty can be imposed together. Last but not least, while punitive damages exist in the Anglo-American law, punitive damages were not legislated in Korea. However, legislators introduced the punitive damages in SAPA. If severe accident occurs, the company can be responsible for damages up to 5 times of the amount of damages. Now, what I'd like to tell you additionally is SAPA is not applied to the business or workplace which hires less than 5 full-time employees. In addition, by a transitional provision, SAPA is not applied to the business or workplace which hires less than 50 full-time employees until January 2024.
Well, thank you so much for that comprehensive overview. Would you say there were any changes since the enactment last year?
Well, since SAPA enacted a year ago, the Ministry of Employment and Labor and other ministries have published the guidelines of SAPA. And last October, the enforcement ordinance of SAPA was enacted. The enforcement ordinance went into effect from yesterday, along with SAPA. What is quite noticeable in the business field is that large Korean companies have been quite busy improving their internal safety and health system. But it seems that small and medium companies are not quite paying serious attention to SAPA. Another thing I'd like to mention is in many multinational companies or joint venture companies, foreigners are not quite willing to be appointed as CEOs in Korea. It might be because foreign CEOs already know the safety risk which SAPA poses to them.
Mm-hmm. What would be considered, quote unquote, serious accidents?
Well, according to SAPA, serious accidents can be divided into two categories. One is a serious industrial accident, and other is a serious civil accident. Serious industrial accidents occur when serious accidents occur in the business or workplace which an employer effectively governs, operates, or manages. Serious civil accidents occur when an accident occurs not to the employees but to the general public. Serious civil accidents occur when defects in design, manufacture, installation, or management of a specific raw material or product, public facilities, or public transport result in accident. Serious accident occurs not only in death cases, but in injury or disease cases. For a serious industrial accident, the requirement is more than 2 injured people from same accident or 3 people with same disease. For serious civil accidents, the injured people from same accident or people with the same disease should be more than 10.
What would you say the obligations then are for corporations under this act?
Well, the enforcement ordinance of SAPA details the obligations of employers. First, employers need to set up a goal for safety and health and management policy. And next, employers need to organize a team which controls the safety and health of the company. Also, the procedures to check harmful risk factors should be prepared. And employers need to formulate budgets for accident prevention and need to support the business, the chief security officer. The next thing employers should prepare is that employers need to have safety and health experts in the company. In addition, the opinion hearing procedure needs to be set up, and there should be a specific manual for serious accidents. And finally, the evaluation criteria to check the industrial accident prevention of contractors should be prepared.
And if a violation occurs, what generally are the penalties?
Well, in case of an employee dies of industrial accident, imprisonment of no less than 1 year or monetary penalty of no more than 1 billion won is imposed. In case of injury or disease, imprisonment of no more than 7 years or monetary penalty of no more than 100 million won is imposed. The imprisonment and monetary penalty can be imposed together. Under SAPA, an article for dual liability exists. It means that not only the CEO, but the company itself receives monetary penalty. In case of death, no more than 5 billion won is imposed on the company. And in case of injury or disease, no more than 1 billion won is imposed on the company. What I mentioned about the penalties is applied to both serious industrial accidents and serious civil accidents.
Final question here then, because it is very much a kind of corporation advocacy point of view so far, but what do you think corporations have to keep in mind with SAPA?
Well, it seems that many companies are not paying serious attention to SAPA, thinking that SAPA is quite similar to the previous act. However, SAPA is totally different from the previous act. Under the previous act, if companies conducted a formal procedure, which means just checking their checklist, but they could avoid the penalties. However, under SAPA, what is important is whether companies effectively perform the safety and health obligations. So we cannot say that companies are well prepared for SAPA if they just stick to their previous measures. Another thing I'd like to comment is there should be an information pipeline from workplace to the CEO. This information pipeline means that the safety information flows both ways. Under the previous act, the CEOs were immune from obligation if they say they did not get any safety report. However, under SAPA, the fact that the CEOs did not get any safety report can mean that they did not conduct the safety and health obligations. The last thing I'd like to comment is the internal rapid reaction team for serious accidents is essential. If there is an industrial accident on the previous act, it was just a simple industrial accident case. However, under SAPA, it is a criminal case in which the CEO is a suspect. Under SAPA, any industrial accident can be a serious case which can threaten the existence of the company. So having a rapid reaction team inside the company is so essential. That's all I prepared for SAPA. Thank you very much.
All right, Kim Seung-jin from DR and Aju, thank you for joining us.